Hello, thank you for joining me. Lawyers from different parts of the world have decided to join hands together to fight against the illegal sentencing of Nnamdi Kanu. The life sentence will be overturned because this group or team of lawyers from different parts of the world, not only Igbo, not only Yoruba, not only Hausa, they are from different parts of the world. And they said no, that this sentencing of Nnamdi Kanu will not be allowed to stand. And they have put something together that is going to really blow your mind. So we are going to read together from the beginning to the end. Please don't log out. Join me as we read together. The Nnamdi Kanu life sentence must be overturned. He is in Sokoto prison. He will not be there permanently. As we continue in prayers and also important updates, walking together with faith, God will hear us. God will answer our prayers. I begin to read from number 1. We have about 17 items to read. 17 items to read. Number 1. Nnamdi Kanu was convicted under a law that is no longer in existence, even though a new law had already replaced it. What is the proof? At the time that the judgment was delivered, the Terrorism Prevention Amendment Act of 2013 had been repealed. You remember, this was also mentioned in my previous broadcasts. Now, Section 36, subsection 12 of the Constitution forbids conviction unless the offense is defined by a law in force at trial and conviction. Justice Omotosho was repeatedly reminded of this repeal by Nnamdi Kanu himself. Show me the law. Nnamdi Kanu asked him repeatedly. Instead of deciding the issue, the judge repeatedly said, wait for judgment. Now, under Section 122 Evidence Act, repeal is a matter of law requiring judicial notice, not delay. NNPC versus Fayemi, court must take judicial notice of statutes and repeal automatically, or else they act without jurisdiction. What is the consequences of this? The conviction was entered without jurisdiction. So the conviction of Nnamdi Kanu was entered without jurisdiction. So a conviction without jurisdiction is void from inception, which is this conviction of Nnamdi Kanu. It is void. Retrial is bad because the state prosecuted under a dead law when a living one existed. I hope you're following. I hope you're following. That is why we stand and say this evil verdict must be overturned. Number 2. After admitting that conviction under a repealed law is illegal, the judge still went ahead and convicted Nnamdi Kanu. What is the proof? On record, Justice Omotosho accepted the basic legal truth. You cannot convict under a repealed law. This admission was made while Nnamdi Kanu was unrepresented and relying on the court's candor. Under the doctrine of judicial estoppel, a court cannot accept a legal position and later act against it. Ogejofo versus Ogejofo, courts are bound by positions they induce parties to rely upon. The court later reversed itself silently in judgment. What is the consequence? The proceedings became a constitutional ambush. The conviction is legally dishonest. Retrial is bad. Is bad. Not as in BAD, but as in BARRED. Is bad. Is prevented. Is stopped. To prevent the state from profiting from judicial self-contradiction to stop the state from benefiting from judicial self-contradiction. Now, number 3, charge. The court refused to decide whether it had legal power to try Mazi Nnamdi Kanu, but still jailed him. Proof. Jurisdiction was challenged repeatedly in writing and orally. Madokolo versus Nkamdelem, jurisdiction must exist before a court acts, which does not exist before the court began to try Nnamdi Kanu. Justice Omotosho deferred jurisdiction to judgment. He said, I will tell you in judgment. You will hear it during the judgment. And then if you want to make any objection, you can make any objection during the judgment. Just hold on. Follow me as we read together. A lot of things are to be read. I don't want to analyze anything. They are all self-explanatory. Justice Omotosho deferred jurisdiction to judgment. A court cannot postpone the source of its own authority. Consequence. Every step taken by Justice Omotosho was legally nullity. Legally nullity. It is null and void. The trial was conducted without jurisdiction. The conviction collapses automatically. Interesting. Number 4, charge. The court used a savings clause to keep a dead law alive and jailed Mazi Nnamdi Kanu. Proof. Section 98 subsection 3 of TPPA was cited as justification. Savings clauses preserve continuity only through transition, not against transition. Section 97 of TPPA mandates movement to the new law, nothing else. Justice Omotosho acknowledged transition in his judgment, but never transitioned anything. I hope you're following. What is the consequence? The court resurrected a corpse statute. This violates separation of powers. The conviction is constitutionally impossible. Therefore, it is null and void. It is null and void. It cannot stand. Number 5. Charge. Kanu was tried under a mixture of old and new laws that does not exist anywhere in Nigerian law. Mazi Nnamdi Kanu was tried under a mixture of old and new laws that does not exist anywhere in Nigerian law. What is the proof? Parts of the judgment relied on TPAA repealed, dead. Other parts reference TPPA not applied. Criminal liability must arise from one identifiable law, not a judicial college. Not a judicial college. Section 36, subsection 12 requires a single written law. A single written law. Not you go and collect this one, you bring this one, you combine it together, which is called judicial college. No. Single. Not mixture. What is the consequence? A fictional law cannot imprison a human being. The entire trial is a legal hallucination. Conviction is void. Void. Number 6. Charge. The judge refused to take judicial notice that the law had been repealed. He refused to take judicial notice that the law he was trying to use to convict Mazi Nnamdi Kanu has been repealed. Proof. Repeal is a matter of law, not evidence. Section 122 of Evidence Act mandates judicial notice. Example, in NNPC versus Fayemi, makes this duty compulsory. Justice Omotosho instead said, assume without conceding assume without considering. Consequence, a court cannot assume. A court cannot assume its own jurisdiction. Every act thereafter lacked legal authority. Conviction is null. It is null and void. Let me say this. Mazi Nnamdi Kanu has not been convicted legally, constitutionally, lawfully. He has not been convicted. Number 7, charge. The court forced Kanu to defend himself even after accepting that no lawful conviction could arise. The court forced Nnamdi Kanu to defend himself, to enter defense, even after accepting that no lawful conviction would be possible. Proof. Repeal was acknowledged. Defense was still compelled, which is wrong. A court cannot force defense where jurisdiction is absent. Never. This reverses the presumption of innocence, which ought not to be. Consequence. The proceedings became coercive, by fire by force, coercive. The trial lost adjudicatory character. The trial lost adjudicatory character. Conviction cannot stand. Number 8, charge. The trial continued after it had already become legally pointless. Proof. Once repeal was accepted, no conviction could lawfully follow. All subsequent proceedings served no legal purpose. Courts exist to adjudicate lawfully, not to perform rituals. You can also use translation when you go to the description of this video. If you go to the description of this video, you can tap translation, so that what I'm reading out, you can also be seeing it on the screen. We must continue. Omotosho is finished. Consequence. Let me read from the top. Number 8. The trial continued after it had already become legally pointless. Proof. Once repeal was accepted, no conviction could lawfully follow. All subsequent proceedings served no legal purpose. Courts exist to adjudicate lawfully, not to perform rituals. Consequence. The trial became punitive theater. The trial became punitive theater. Retrial is bad. B-A-R-R-E-D. Acquittal at this point became mandatory. What Justice Omotosho was supposed to pronounce is that Mazi Nnamdi Kanu is hereby discharged and acquitted. It was mandatory as at this time, but he failed to deliver, to do justice to it. He failed. Because of bribe, because of money, because of hatred, because his brother is the president. And his brother is the prosecutor. He's finished. At this point, acquittal is mandatory. Understood. Same pressure, same clarity, same tampering. Below is batch 2, continuing the recast of existing points that the lawyers have put together against this very evil verdict against Mazi Nnamdi Kanu. Number 9, charge. Nigeria had no right to try Mazi Nnamdi Kanu for alleged broadcasts made in the United Kingdom. Okay, proof. The prosecution's case was anchored on broadcasts made from London, United Kingdom. I hope you're following. criminal jurisdiction is territorial unless strictly expanded by statute. It is territorial. You can't wave it away. The Terrorism Prevention and Prohibition Act, which is TPPA, requires compliance with extraterritorial gateways, including double criminality. No evidence was led that Nnamdi Kanu, his alleged broadcasts, were criminal offenses. No evidence was presented to the court. Under the UK law, that his broadcasts were criminal offenses, under the UK law, there was no such evidence presented in court. Justice Omotosho never determined where the offense occurred before assuming jurisdiction. He's supposed to have determined where the offense occurred, offense in quotes, before assuming jurisdiction. What is the consequence? Jurisdiction was assumed, not earned. He didn't earn it. He assumed jurisdiction. A Nigerian court cannot jail a man for conduct lawfully done abroad. The conviction is void from inception. Number 10. The court never proved that anything Kanu allegedly said was heard or acted upon in Nigeria. The court did not prove it, that whatever they claim that Nnamdi Kanu said was heard or acted upon in Nigeria. They couldn't prove it. No witness testified that they listened to Kanu's broadcasts. None of them. They kept on telling the court, I don't know, I'm not aware. You remember when those witnesses came to court? All the questions that the defense team were asking them, they say, I don't know, I'm not aware. Interesting. Don't log out. Like and share this video. No witness testified that they listened to Kanu's broadcasts. No evidence of reception, audience, or Nigerian listener was produced. No such evidence. Speech cannot intimidate, incite, or terrorize in a vacuum. Criminal law requires impact, not imagination. Assumption, no. Consequence. Essential elements of the offense were missing. The prosecution proved content, not effect. Conviction collapses automatically. Number 11. The prosecution secretly removed London, United Kingdom, from the charge after spying on Kanu's legal consultation. They now removed London. They now removed United Kingdom from the charge when they got intel or leaked secret from the consultation of Nnamdi Kanu's legal team. They thought they were smart. Proof. During a October meeting at DSS headquarters, the British consul met with Nnamdi Kanu. Nnamdi Kanu raised the legality of trying him in Nigeria for an offense allegedly committed in the United Kingdom. So they leaked the information to Nigeria, and Nigeria now quickly and secretly removed London and UK from the charge they preferred against Nnamdi Kanu, because they know that we deny them of the jurisdiction to try him. Now, what is the consequence? Okay, still under the proof. Shortly after the consul, the UK consul, met with Nnamdi Kanu in the DSS dungeon. Shortly after that, the prosecution removed the UK location from the charge sheet. That was what they did. This was a deliberate attempt to evade territorial jurisdiction scrutiny, so that the territorial jurisdiction of the case will not be scrutinized. So they quickly expunged it from the charge sheet. What is the consequence? The charge was manipulated through illegal eavesdropping. Prosecutorial misconduct of this nature poisons the entire case. Listen again. The charge was manipulated through illegal eavesdropping. Prosecutorial misconduct of this nature poisons the entire case. The conviction is unsalvageable. Number 12. Kanu was abducted, not extradited, not extradited. He was abducted, not extradited. And Nigerian courts cannot try people kidnapped from foreign countries. Proof. Kanu was forcibly abducted in Kenya, as many of you know. No extradition request was made. No Kenyan court approved his transfer. There was no Kenyan court that approved his transfer. Now, Section 46, subsection 1 of ACJA, which is Administration of Criminal Justice Act, requires lawful arrest and presentation before a competent court, which never happened. Kenyan court later declared the abduction illegal. Consequence: custody was unlawful. Jurisdiction never arose. The entire trial is void ab initio. Number 13. A court cannot benefit from an illegal abduction to secure a conviction. A court cannot benefit from an illegal abduction to secure a conviction. Proof. The state chose kidnapping over lawful extradition. International law and the African Charter forbid arbitrary arrest and transfer. Nigerian courts are bound by the African Charter. Example, in the case of Abacha versus Fayemi, Justice Omotosho ignored binding treaty obligations. He ignored it. Consequence: the trial legitimized executive lawlessness. Jurisdiction was morally and legally bankrupt. Retrial is bad. BARRED. Number 14. The court ignored foreign judgments declaring Kanu's abduction illegal. Foreign judgments. One of them is the UN judgment 2022 between the 30th of March and the 8th of April. They ignored it. ECOWAS Court of Justice, Kenyan court, they all ignored them. We are Nigeria. We are full of lawlessness. We will carry it out. In the case of Nnamdi Kanu, nothing will happen. But this case is different. Something will happen. Kenyan court decisions condemning the rendition were pleaded. The prosecution did not challenge them. Courts must give effect to uncontroverted judicial findings. Silence is admission in law. Consequence: the trial proceeded in defiance of binding facts. The conviction is jurisdictionally poisoned. It cannot stand. It can never ever stand. Nnamdi Kanu will win this case. Fair and square. He will not serve the sentence. Nnamdi Kanu in Sokoto prison. Nnamdi Kanu in prison. He will come out. He will not serve this life sentence. Number 15. Charge. The doctrine of mel captus bene detentus cannot save this trial. The doctrine of mel captus bene detentus cannot save this trial. Proof. That doctrine is a dying common law relic. It cannot override Nigerian statutes, which is Section 46, subsection 1 of ACJA, Section 76, subsection 1D and 3 of TPPA, the African Charter or international human rights obligations. The TPPA proscribes extradition, not abduction. What is the consequence? The court relied on an obsolete doctrine to excuse illegality. This is per Coercion. Conviction is void. Number 16. The court never proved double criminality as required by law. Section 76, subsection 1, D and 2. Section 76, subsection 1D and 3 of the TPPA requires that alleged foreign conduct be criminal in both countries, in UK and in Nigeria. But they have not been able to prove whether it is criminal under the UK law. So they removed London and UK in the charge sheet and focused on Nigeria in order to give it jurisdiction, but they failed. No evidence was laid on UK criminal law. No findings was made that Kanu committed any offense under UK law. What is the consequence? A mandatory jurisdictional gateway was never crossed. Remember the threshold which the judge refused to cross. The court never entered lawful territory. Conviction collapses. That is the consequence. Number 17. The trial court punished Kanu for insisting on legality. Because he was insisting on legality, what is legal, they decided to punish him. Jurisdictional objections were treated as delays. As he was raising jurisdiction in the case, they say, oh, you are trying to delay this matter. You are trying to delay it. The court elevated speed over constitutional compliance. They say, oh, it's going to be an accelerated hearing without the compliance with the Constitution. This your so-called accelerated hearing, is it in compliance with the Constitution? The answer is no, but they never cared. All they were shouting is accelerated hearing so that they can quickly jail him. Rights were reframed as obstruction. Consequence, this reverses the hierarchy of law. Courts exist to protect legality, not suppress it. The trial is unconstitutional. The trial is unconstitutional. This is what lawyers from different parts of the world have agreed. They have come together and said, no, we're going to challenge it. It is a nullity. It will not stick. It will not stand. So everybody should be very happy. We are working, we are praying, we are declaring that this evil verdict shall be overturned. It shall not stand. It will never see the light of the day. It doesn't matter all the manipulations surrounding it. It does not matter all the gang up against it. It does not matter all the inhuman treatment against Nnamdi Kanu. We are declaring by the authority of God, nature is behind us. The voices of righteous people in different parts of the world, they are behind us. The ground, the earth, where we live, the territory, where this case was handled, Sokoto, where Nnamdi Kanu is locked in presently, is behind us. They are all behind us. All we need to do is to stand very strong and fight. Fight legally, fight spiritually, fight peacefully, quietly, and actively to overturn this evil verdict, and Nnamdi Kanu will surely come out. God bless you. Make sure you join the Maxwell Nnawuihe's channel membership if you have not joined it, because this is going to give you access to some private videos. You remember I told you in the private, this is for the channel members. I gave you prophecy that the president of Nigeria will visit Nnamdi Kanu in prison. That prophecy is about to manifest. I am hearing something. I believe that some of you have read it on the social media, you have read it on the internet. Now, it is important, those who have not joined Maxwell Nnawuihe channel membership, try and join immediately, because there are a lot of benefits. You will have access to some videos that others don't have access to. and some vital information, including motivational, inspirational, and other powerful contents. God bless you.
Pastor Maxwell Nnawuihe, I call on you. Come and turn things around for the people. My faith is in you. Lord, I call on you today. Come and turn things around. Come and turn things around. Turn things around. Come and turn things around for your children, child. Jehovah Jireh, turn things around. Oh, Papa, turn things around. There is suffering all over Nigeria. The last one, the Mahon, Nagafufu, Umi, Nnamdi Kanu, it's your things around. When you're never United Nations judgment has set him free. We just are not attaching it, and I told you, I'm a man. I will answer you and show you great and mighty things to them. When the righteous man is seated upon the throne, everywhere you go, there is joy, joy, joy. When the wicked man is seated upon the throne, everywhere you go, there is crying, suffer, 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 tire, 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 suffer, suffer. From the east to the west, the mountain of from the north to the south, there is trouble, trouble. Righteousness exalts a nation, but sin is a reproach to any people, any people. Look around Nigeria today, what you will see is reproach. Reproach, we are judging. Mambagaraga, Emapane, Mama, Naboye election, the Mecca Nigeria, with them. Then I got a Yamamamburu, Sinamo, Yamamura. MSC election, Child, we step into the Kabano tribunal. I'm a hedge to go back to Jeben and America. The son of a Kalakaba Supreme Court. It may be a no, it may be a no. I'll be come back when you do it. Nnamdi Kanu, United Nations judgment has set him free. Let him go. Let him go. Baby